Nintendo just made a critical mistake when Palworld launched with creatures that look suspiciously like Pokémon. Everyone expected a copyright lawsuit. But Nintendo went a different route. They sued for patent infringement instead. And now, official documents reveal their strategy is falling apart. Both the Japan Patent Office and the US Patent Office have dealt major blows to Nintendo's case. Here's the verified evidence of what went wrong. Let's set the stage. In January 2024, a small Japanese studio called Pocketpair released Palworld, a survival game where you catch creatures called pals. The internet immediately noticed similarities to Pokémon. Within weeks, Palworld sold 25 million copies, becoming one of the fastest selling games in history. Nintendo stayed silent for months. Then in September 2024, they finally acted, but not in the way anyone expected. Here's what confused everyone. Nintendo didn't sue for copyright infringement. Why? Because copyright protects specific artistic expression. The exact look of Pikachu, for example. But Palworld's creatures, while similar in style, aren't direct copies. Legally, that's a weak case, so Nintendo chose patents instead, claiming they own the mechanics of catching creatures in video games. This was a strategic gamble, and it's now backfiring spectacularly. Let's examine the official patent documents. Nintendo filed multiple patents in Japan and the United States covering game mechanics like throwing an object to capture a creature, riding captured creatures in an open world, and switching between mounts during gameplay. These patents were filed after Palworld's announcement, a tactic called patent layering, designed to build a legal arsenal. But there's a massive problem with this strategy. For a patent to be valid, the invention must be novel, meaning no one did it before. This is called prior art. And here's Nintendo's problem. Dozens of games had creature catching and riding mechanics years before their patents. Ark Survival, Evolved, 2015. Monster Hunter, 2004. And here's the embarrassing part. Pokémon GO, Nintendo's own game, was cited as prior art that invalidates their claims. They're being defeated by their own product. Pocketpair didn't just accept Nintendo's claims, they fought back with a brilliant legal strategy. In April 2025, they filed detailed prior art submissions with both the Japan and US patent offices. Their list included not just commercial games, but also game mods, fan-made modifications like Pixelmon for Minecraft, and various creature-catching mods for other games. This unconventional approach triggered a legal battle over what counts as prior art. In October 2025, the Japan Patent Office delivered a devastating ruling. Nintendo's patent application 2024-031879 was rejected. The official reason? Lack of originality. The Patent Office cited Ark Survival Evolved, Monster Hunter 4, Craftopia, and, in an embarrassing twist, Pokémon GO itself as prior art. The very mechanics Nintendo claimed to have invented already existed in games they knew about. Let's appreciate the irony here. Nintendo tried to patent throwing an object to capture a creature in an open world. But Pokémon GO, released in 2016, developed with Nintendo's involvement, does exactly that. You throw a Pokéball at creatures in an augmented reality open world. The Japan Patent Office essentially said, you can't patent something your own company already released to the public years ago. This is a textbook case of prior art invalidation. The trouble didn't stop in Japan. In November 2025, something extraordinary happened at the United States Patent Office. The USPTO director personally ordered a re-examination of Nintendo's US patent number 12,400,3397. This is incredibly rare, the first time in over a decade that a USPTO director has personally intervened in a patent dispute. The reason? A 2002 Konami patent that predates Nintendo's claims by over 20 years. The Konami patent from 2002 describes game mechanics remarkably similar to what Nintendo claims to have invented. Capturing creatures, storing them, using them in gameplay, all documented over 2 decades before Nintendo's Palworld-related filings. This single piece of prior art could invalidate Nintendo's entire US patent strategy. The re-examination process typically takes 12 to 18 months, but the outcome could reshape gaming patent law entirely. Nintendo's legal team made a controversial argument. Fan-made mods shouldn't count as prior art. Pocketpair cited Pixelmon, a Minecraft mod with Pokémon-style creature, catching, and various other fan modifications. Nintendo argued these unofficial modifications aren't legitimate prior art because they weren't commercially released products. But legal experts say this argument is risky. If courts rule that mods do count, Nintendo could face an avalanche of prior art claims from the massive modding community. This case goes far beyond Palworld. If Nintendo's patents had been upheld, they could theoretically claim ownership over any game with creature-catching mechanics. Temtem, Cassette Beasts, Monster Crown, dozens of indie games could have faced legal action. The Patent Office rejections send a clear message. You cannot patent broad gameplay concepts that have existed across the industry for decades. This is a victory for game developers everywhere. Nintendo built its reputation on innovation and beloved franchises, but their aggressive legal tactics have drawn criticism from fans and industry observers alike. From shutting down fan games to this patent dispute, Nintendo's legal department has become almost as famous as their game studios. This Palworld case may force Nintendo to reconsider their approach. When your own products are used against you in court, perhaps it's time to compete through innovation, not litigation. The battle isn't over. The Japan lawsuit continues despite the patent rejection. Nintendo has other patents in their arsenal. A US lawsuit is expected in spring or summer 2026, and Nintendo can appeal the Patent Office decisions, but each rejection weakens their position. Pocketpair has shown that even a small studio can fight back against industry giants, if they have the evidence and the will to use it. Nintendo vs. Palworld shows that even the biggest companies can't patent ideas that belong to everyone. But not every David vs. Goliath story ends the same way. Next on Patent Wars, a tiny Texas startup is suing Nvidia, the $3 trillion AI giant, for $4 billion. And unlike Nintendo's rejected patents, this startup might actually have a case. Their technology may be inside every AI chip you've ever used. Subscribe to see the official court documents.